Today, I am Jolene Mimuka and I'm going to recite Article 14 and 15. So Article 14, Aggravating Circumstances. The following are aggravating circumstances. 1. That advantage be taken by the offender of his public position. Requisites. 1. The offender is a public officer. 2. The commission of the crime would not have been possible without the powers, resources, and influence of the office he holds. The essentials is public officer use the influence, prestige, or ascendancy which his office gives him as a means by which he realizes his purpose. Failure in his official is tantamount to abusing of office. Wearing of uniform is immaterial. What matters is the proof that he indeed took advantage of his position. 2. That the crime be committed in concept of or with insult to the public authorities. Requisites. 1. The offender knows that a public authority is present. The public authority is engaged in the exercise of his functions. 3. Public authority is not the victim of the crime. 4. The public authority's presence did not prevent a criminal act. Example of this is Juan and Pedro are quarreling and the municipal mayor, upon passing by, and attempt to stop them. Notwithstanding the intervention and the presence of the mayor, Juan and Pedro continue to quarrel until Juan succeeds in killing Pedro. Person in authority. Public authority who is directly vested with jurisdiction has the power to govern and execute the laws. Examples of persons in authority. 1 is governor, mayor, barangay captain, councilor, government agents, chief of police. The rule is not applicable when committed in the presence of a mere agent. Agent, subordinate public officer charged with the maintenance of public order and protection and security of life and property. Example is Barrio Vice Lieutenant, Barrio Councilman. 3. The act to be committed with insult or in disregard of the respect due to the offended party on the account of his rank, age, sex, or that it be committed in the dwelling of the offended party if the latter has not given provocation. Circumstances, rank, age, sex may be taken into account only in crimes against persons or honor. It cannot be invoked in crimes against property. Rank refers to a high social position or standing by which to determine one's pay and emoluments in any scale of comparison with a position. Age. The circumstances of lack of respect due to age applies in case where the victim is of tender age as well as of old age. Sex refers to the female sex, not to the male sex, not applicable when the offender acted with passion and obfuscation. There exists a relation between the offender and the victim, but in cases of divorce decrees where there is a direct bearing on the child, it is applicable. The condition of being a woman is indispensable in the commission of the crime. Example is parricide, rape, abduction. Requisite of disregarding to rank, age, or sex. Crimes must be against the victim's person of his honor. There is deliberate intent to offend or insult the respect due to the victim's rank, age, or sex. Disregard to rank, age, or sex is absorbed by treachery or abuse of strength. Dwelling must be a building or structure exclusively used for rest and comfort. Combination of house and store not included. May be temporary as in the case of guests in a house or bed spacers. Basis for this is the sanctity of privacy the law accords to human abode. Dwelling includes dependencies, the foot of the staircase, and the enclosure under the house. Elements of the aggravating circumstance of dwelling is number 1, crime occurred in the dwelling of the victim. Number 2, no provocation on the part of the victim. Requisites for provocation, all must concur. 1, given by the owner of the dwelling. 2, sufficient. 3, immediate to the commission of the crime. So, when dwelling may and may not be considered. When it may considered by although the offender fired the shot from outside the house, as long as his victim was inside, even if the killing took place outside the dwelling, so long as the commission began inside the dwelling. And when adultery is committed in the dwelling of the husband, even if it is also the dwelling of the wife, it is still aggravating because she and her paramour committed a grave offense to the head of the house. In robbery with violence against persons, robbery with homicides, abduction, or illegal detention, and if the offended party has given provocation. When it may not be considered, the victim is outside his or her dwelling, and if offended party are not occupants of the said dwelling. 4, that the act be committed with abuse of confidence or obvious ungratefulness. Requisites of abuse of confidence. A, offended party has trusted the offender. B, offended abuse such trust. C, abuse of confidence facilitate the commission of the crime. And the requisite of obvious ungratefulness. A, ungratefulness must be obvious, that is, there must be something which the offender should owe the victim a debt of gratitude for. The note: robbery or theft committed by the visitor in the house of the offended party is aggravated by obvious ungratefulness. Example is a jealous lover, already determined to kill his sweetheart, invited her for a ride, and during that ride he stabbed her. Abuse of confidence is inherent in malversation, qualified theft, estafa by conversion, misappropriation, qualified seduction. 5. The crime that the crime be committed in the palace of the chief executive or in his presence, or when public authorities are engaged in the discharge of their duties, or in a place dedicated to religious worship. Requirements of the aggravating circumstances of public office. Appalling present is a public office during election day. Nature of public office should be taken into account, like a police station which is on duty 24 hours a day. Place of the commission of the felony, if it is a Malacanang palace or a search, is aggravating regardless of whether state or official functions are being held. As regards other places where public authorities are engaged in the discharge of their duties, there must be some performance of public functions. The offender must have intention to commit a crime when he entered the place. Requisites for aggravating circumstances for place of worship. 1 is the crime occurred in the public office. 2, public authorities are actually performing their public duties. The crime occurred in the place dedicated to the worship of God, regardless of religion. An offender must have decided to commit the crime when he entered the place of worship. When paragraph 2 and 5 of Article 14 are applicable. So, committed in the presence of chief executive in the pre- presidi- presidential palace or a place of worship. Public authorities are performing their duties when the crime is committed. When the crime is committed in the public office, the officer must be performing his duties except in the presidential palace. Public authority may be offended party. Committed in contempt of public authority. Outside the office is still performing duty. Public authority is not the offended party. 6A. That the crime be committed in the nighttime or in an place by a band whenever such circumstances may facilitate the commission of the offense. Nighttime, uninhabited place or by a band aggravated when. Impunity means to prevent the accused being recognized or to secure himself against detection or punishment. Nighttime begins at the end of the dusk and ending at dawn from sunset to sunrise. An uninhabited place, one where there has no houses at all. A place at a considerable distance from town, where the houses are scattered at a great distance from each other. 1. It facilitates the commission of the crime, especially sought for by the offender to ensure the commission of the crime or for the purpose of impunity. When the offender took the advantage, therefore, for the purpose of impunity, commission of the crime must begin and accomplished at nighttime. Commission of the crime must begin and be accomplished at the nighttime. When the place of the crime is illuminated by light, nighttime is not aggravating, absorbed by treachery. Requisites. 1. The place facilitated the commission or omission of the crime, deliberately sought and not accidental to commission or omission of the crime, taken advantage of for the purpose of impunity. What should be considered here is whether in the place of the commission of the offense there was a reasonable possibility of the victim receiving some help. 6b. Whenever more than 3 armed malefactors should be acted together in the commission of an offense, it shall be deemed to have been committed by a band. Requisites. If one of the 4 armed malefactors is the principal by inducement, they do not form a band because it is undoubtedly connoted that he had no direct participation. Band is inherent in robbery committed in band and brigandage. It is not considered in the crime of rape. It has been applied in treason and in robbery with homicide. 1. Facilitate the commission of the crime, deliberately so, taken advantage for the purpose of impunity, before there must be 4 or more armed men. 7. That the crime be committed the occasion of the conflagration, shipwreck, earthquake, epidemic, other calamity, or misfortune. Requisites. Committed when there is a calamity or misfortune, conflagration, shipwreck, epidemic. Offender took advantage of the state of confusion or chaotic condition from such misfortune. The basis. Commission of the crime adds to the suffering by taking advantage of the misfortune. Based on time, offender must take advantage of calamity or misfortune. Distinction between paragraph 7 and 12 of Article 14. Committed during a calamity or misfortune, committed with the use of wasteful means. Crime is committed during any of the calamities. Crime is committed by using fire, inundation, explosion, or other wasteful means. 8. That the crime be committed with the aid of armed men or person who ensured of afford impunity. Based on the means and ways that the armed men or person took part of the commission of the crime, directly or indirectly, that the accused involved himself, their aid, or relied upon them when the crime was committed. Exception when both the attacker party by the party attacked by equally armed, not present when the accused, as well as those who cooperate with him in the commission of the crime, acted under the same plan and for the same purpose. Casual presence, or when the offender did not avail himself of any of their aid, nor did not knowingly count upon their assistance in the commission of the crime. With the aid of armed men, presence, even one of the offenders merely relied on their aid. Actual aid is not necessary. By a band, requires more than 3 armed malefactors who all acted together in the commission of an offense. If there are more 3 armed men, aid of armed men is absorbed in the employment of the band. That the accused recidivist, is recidivist, one who at the time of his trial for one crime shall have been previously convicted by final judgment of another crime and based in the same title of Rpc basis greater preservative the offender as shown by his inclination to commit crimes. Requisites: 1. Offender is on trial for an offense.